So our next speaker for today is known to all of us as one of Australia's most passionate and most well-known advocates for liberty. Tim Wilson is the Australian Human Rights Commissioner, although better known, I think, to all of us here as the Friedman Commissioner.
Yeah.
And in that role, he's actually standing up for real human rights, as opposed to what the human rights industry might think are human rights, which is, in fact, quite the opposite of it. Tim has had a long association with liberty. He was the keynote speaker at our annual dinner at the Friedman Conference last year. Prior to becoming the Australian Human Rights Commissioner, he was the Director of IP and Free Trade at our very good friends at the Institute for Public Affairs, a great organisation and a supporter of ours here, who also have a stall, so I encourage you to check out their materials. So without any further ado, I'd like to welcome Tim Wilson to the stage.
Am I allowed to close this? Yes, that's right. I don't want to damage anybody else's property rights in light of the fact that that's the subject of my talk. Well, thank you, Tim, so much for that very, very kind introduction. Oh, you'll just have to put up with that in the background. Thank you very much for that extremely kind introduction, Tim. It's such a great pleasure to be here. But I really want to start by acknowledging you and John for doing such an outstanding job in organising this conference in its third year. And having been at all three of them in different capacities, the professionalism that has continued to increase the conference, the lineup of speakers, and as I got a series of emails, as I'm sure you did, continuing to remind me that this was the best list of speakers that this conference has ever had or has ever been assembled in Australia, I think is beyond dispute. And that you really do deserve to be congratulated on your outstanding work. And I actually think we owe Tim and John a round of applause. Also, you have a problem. You've set a very high benchmark. And now you have to repeat it next year and go above and beyond. So good luck with that.
Just bring you back every year.
And also I really want to pay acknowledgement to Tom, because Tom is an absolute rock star in the liberty movement, not just here, not just in the United States, but around the world. Tom, you may not realise this, but I used to sort of hold you on a bit of a pedestal. I guess I still do, but I always used to think when I read your biography and what you've been up to, how much I wish I had the opportunity to do exactly the same type of work you do, go behind enemy lines, engage in discussion on liberty where people are perhaps not overly friendly about it. I'll leave my comments there. But how much I admire you and the contribution you do, and the fact that you make the ideas of liberty so lucid and capable of being connected for people. And one of the things you were talking about specifically before, which is the importance of freedom and its relationship to responsibility. There was an excellent quote that surmised the necessity for people to have freedom to take responsibility in Noel Pearson's recent quarterly essay, which was talking about mostly about constitutional recognition, a completely different subject for Aboriginal people. But he talks specifically about one of the key problems facing Aboriginal Australians was the denial of their freedom to take responsibility and the human consequences that come directly as a consequence of limiting that right, and how essential it was, if you want Aboriginal communities to achieve higher degrees of economic participation, better economic and social welfare standards, that the freedom to take responsibility was at the heart of solving that very complex problem. But I'm actually going to return to some of that in some of my address shortly. Because I completely agree with you about the need to take responsibility as part of the human rights discourse, and that too often it's been left out as part of the discussion. I'll get to property rights in a minute. But we saw that earlier this week, where there was this long ongoing debate about the degree and the limits of free speech, and that some people now seem to think that freedom of speech doesn't involve people being held to account by others. And I'm talking particularly with relation to the matter of SBS and Scott McIntyre. And while I continue to assert that I don't think SBS should have sacked him, but they felt their hand was forced because of the particular situation they were faced with. What I was shocked and amazed at was how many people tweeted abuse primarily at me, but also at others, that they thought that freedom of speech no longer included a degree of accountability and responsibility for what you say, and that other people can't exercise their freedom of association, to disassociate yourself from somebody who you think is engaging in some type of activity which you consider to be inappropriate or unjust. It's in that contest between individuals that we exercise responsibility and we establish what is moral and civil, and that should be an enormous part of the discussion. And we really need to reassert that important principle in the discussion, not just about human rights in Australia, but about morality and civility in the public square. Now on to property rights. Throughout the second half of last year, I ran a national consultation looking at the human rights challenges faced in Australia, and particularly the role of free speech and association, religious freedom and property rights. Because when you arrive at the Human Rights Commission, you get told a number of things. I won't go through all of them, but one of the most important is you spend your first year as Human Rights Commissioner figuring out roughly what you're going to do. The next 3 years you spend actually trying to do it, and the last year you wrap things up. And so we held this national consultation to really go out there and say, well, if we believe in these important liberal human rights like free speech and association, religious freedom and property rights, where are the issues and where are the opportunities to effect change? So that at the end of my 5 years, I haven't just been a soundbite, but actually Australia is a more free and prosperous country for everybody. And in particular, property rights came out as a consistent theme, which the Human Rights Commission, I confess, didn't really think was a particularly important issue as part of their discussion. In fact, my staff thought it was going to be the part where we were going to get the least feedback from the Australian public from. In fact, it was consistently the most important part of public discourse. George Williams, the professor, constitutional professor at University of New South Wales, once told me that of all of the issues he gets letters from the public from around human rights and freedoms, that goes completely unattended to is always property rights issues, and that they're completely ignored by far too much of academia and are not considered part of the human rights discourse. So when we held these consultations, and we had many of them held in public forums all across the country, many people disagreed with the focus of the consultations because they thought I should be focusing on things that perhaps were much more consistent with the current understanding of human rights, which, needless to say, wasn't necessarily what I was interested in focusing on. But it was that property rights drew the most criticism. At a forum in Brisbane, a representative of Amnesty International got up and politely gestured in my direction as I was standing at a lectern now, and asked me why I was including property rights as part of human rights consultations at all. The woman from Amnesty demanded I answer and outline who was it that was pushing this agenda onto my agenda and what were the interests that were involved. Now, I sort of did a simple thing, we're talking in human rights language and on a ground that Amnesty International should understand, which is to advance the Universal Declaration of Human Rights. In fact, it's in their charter to do so. So I gave the simple answer, which is that Article 17 of the Universal Declaration of Human Rights states that everyone has the right to own property alone, as well as in association with others, and that no one shall be arbitrarily deprived of their property. That's a pretty simple proposition. And so I thought that was sufficient, but needless to say that Representative Amnesty International didn't agree. Then another woman got up and did, as sometimes people do, had a very stern look after I'd spoken for about 15 minutes, gestured towards me thinking that I was about to get another barrage, and instead gestured towards me and turned around to the woman from Amnesty International. And she'd started to state that she'd been involved in the development of the European Charter of Human Rights and how important it was that finally somebody was actually standing up for property rights as part of the human rights discourse. Because the practical reality is that so many human rights issues go back to the denial of property. Property rights and older people is a huge issue, particularly when they're coming towards latter stages of their life and people make informed consent about disposing their property rights when they go into aged care facilities. Similarly, for people who live in caravan parks, often some of the poorest people and most marginalised people in our communities, because it's the only way they can secure affordable housing for themselves. And what happens when caravan park owners sell their property and sell their park, and what happens to those people and also the contributions or the additions they add to their property. Now, of course, for us that's a legalistic question that can be resolved by recognising the different titles and various different types of contracts. But these have real and very important human consequences. and particularly for the poorest and the most vulnerable. Because the rich and the powerful can always take care of themselves and advance and protect their interests. It's the poor and the powerless that need their property rights respected more than anybody. But the much more complex answer to the woman from Amnesty International requires explaining that you can't actually have an understanding of human rights unless you support the sanctity of property rights. This year, of course, is the 800th anniversary of Magna Carta. And the Great Charter essentially commenced the snowballing effect that led to the broad understanding of the modern concept of human rights. The Charter of 1215 established a clear principle that a person's property cannot be seized by the king. And I know there was a robust discussion recently on my Facebook page when I rewatched Disney's version of Robin Hood. If you haven't seen it, trust me, you need to go back and watch it again. It is hilarious. At least the way Disney portrays it, the only person worth stealing from is, in their movie, Prince John, which of course we know to be King John, for one very simple reason. Because he overtaxed everybody too much and stole people's property. And that period was very much about the compulsory acquisition of people's assets through exorbitant taxation without consent, and that this actually fundamentally upset people and led to, of course, the barons running to him on Runnymede. The simple proposition provided from Magna Carta is essentially the foundation of the common law inherited by Australia from England and the, albeit limited, property rights protection in our constitution, and I think there'd be a fair number of people in the room who would like to see that bit strengthened. But of course it was then John Locke that cultivated the property rights were a part of the human rights discussion. In his second treatise, Locke argued the moral case that every man has a property in his own person, the labour of his body, and the work of his hands, we may say properly are his. Locke continued by reasoning that when you value add to an existing asset, that then becomes an individual's property. And what Locke understood, and has been largely lost from human rights discourse, is that property is the moral and just reward of an individual society. Denying property is akin to denying someone of the reward for their labours. That argument was clearer to make when you were arguing for peasants to keep the reward of their farming labour on the commons, to grow their own food, but the complexity of a modern market economy does not make it any less just, whether it's a person's physical or intellectual labours. The economic case for property rights has been amply demonstrated throughout history. Societies, of course, that have been able to meet the material needs and aspirations of its population have been built on property rights. Peruvian development economist Hernando Soto demonstrated the harsh consequences of what occurs when property rights and titles are absent in his great book, The Mystery of Capital. And if those things are absent, then you don't get economic and social development. But property rights sit against a critical backdrop to all rights-based arguments. That is, it must also be seen to be moral, fair and just, particularly in a society such as Australia's. Moral rights have been central to the development of intellectual property, particularly copyright that afford ownership and the right to receive reward from an individual's artistic creation. In his essay on the right to private property, American political philosopher, and I know that Tom just mentioned him, Tibor Machan, correctly identifies that private property is the social precondition of the possibility of a personally guided moral life. In the absence of property rights, individuals are essentially debilitated in their capacity to demonstrate generosity to others. All charity rests upon private property. If people do not own anything, then they can never give anything to anyone else. But the real justification for property rights is, of course, that it's a human right. And if you take the progressive contemporary script on property rights, they aren't really about rights, they're just about protecting existing privileges that exist within our community. In practice, it's a demonstration of just how adrift many people are from understanding the very nature and origin of human rights. I had a disturbing recent participation in a roundtable with the UN Special Rapporteur on cultural rights. She came to, in fact, I think it was this university, We sat around a table with a whole series of different interested parties talking about what cultural rights meant and how to preserve and protect them, and particularly its relationship to property rights. But during that discussion, I was constantly asked, how is it we balance human rights and property rights? Of course, I asserted the somewhat obvious point that they are one and the same things before I was scoffed at by most people in the room, including the UN Special Rapporteur. The fact that there was a complete lack of understanding of the relationship between the two of them all disturbed me greatly and meant I had to make a choice about whether I sat there essentially in frustration throughout the rest of the meeting or essentially walked out. I decided not to appear petulant, so I continued to participate. Arguably, of course, the very foundation of all human rights is property rights. The very basis of natural rights theory is that people own their own bodies and should be free to exercise their faculties, to pursue their lives, their opportunities and their enterprise, unless they do harm to others. It is why liberals, of course, and conservatives oppose and should oppose slavery. In 1959, Dr. Murray Rothbard argued that property rights, far from being in conflict, are in fact the most basic of all human rights. And from this right stems his right to the material goods that he has produced. It's essentially this principle that justifies paid employment, because people own their own bodies and they're able to use their labour, and they should, of course, be compensated for. At the extreme end of the denial of human rights is, of course, slavery. But more modestly, the denial of payment for somebody's labour at a voluntarily established price is a denial of their human rights. When you fundamentally stop somebody going about their lawful business and wanting to seek opportunities to enrich themselves simply because of forms of regulation, it creates a fundamental denial of somebody's capacity to exercise their most basic liberties in the interests of no one. Equally, stopping people from selling their labour at a voluntarily established price is also, of course, fits within that category. Yet despite property rights providing the foundation of human rights, the subject has always been controversial in the modern development and understanding of human rights, particularly through international treaties, and to the extent you think they're relevant or matter to the human rights discussion. As Human Rights Commissioner, if you go and look at the Australian Human Rights Commission Act, I have to give a certain amount of deference towards them. But I'll do that rhetorically, let's put it that way. Property rights was, of course, though, a clear battleground in the development of the 1948 Universal Declaration of Human Rights. A 1947 analysis of the drafts of the Declaration found that, quote, a majority of the drafts refer to the right to property, either in positive language or by prohibiting unlawful expropriation. But views on how broad property rights should be respected was fundamentally a battleground. With support from the Soviet Union and socialist countries, such as Panama, they stressed that respect for private property should be limited solely to personal property. The dispute between countries over property prompted compromises. At one stage, Belgium proposed that, quote, within the limits of public interest, everyone is entitled to own property alone as well as with association with others. One of the central objections to the inclusion of property rights was that it reinforced an individualistic approach to human rights. On that point, at least then, Australia was on the right page. Our delegation identified the absurdity of such an objection, because of course the relationship between individualism and human rights is almost uncontestable. The Australian representative argued that respecting property rights may be, quote, termed individualistic, but in setting forth the rights of individuals, it would be difficult to avoid an individualistic approach. Pretty straightforward logic, I would have thought. In the end, the West actually won that temporary victory. Article 17 established a recognition of property which was undone during the development of the International Covenant on Civil and Political Rights, and if you're not familiar with the difference, the Universal Declaration of Human Rights is just a declaration, a political statement. The ICCPR is a treaty which, depending on your views on international law, is law. In fact, property rights is one of the few rights that were included in the Universal Declaration that isn't then in the ICCPR, because the Soviets won. as they did, for instance, in other aspects of discussion around free speech, where the Universal Declaration does not have restrictions on free speech for things like views on racial matters, but do exist in the ICCPR because the Soviets won. I should also mention that in Article 27 of the Universal Declaration, it gives a framework for recognition of property rights through artistic creation, which creates the framework for the recognition of copyright. There are also references to property rights in the Convention on the Elimination of Racial Discrimination and the Convention on Discrimination Against Women, which focuses on the equal enjoyment of property rights to ensure that women and racial groups are not denied this important right. There is explicit recognition of property rights in the jurisprudence on Article 27 of the ICCPR, coming around copyright, as well as Articles 2 and 5 of the Convention on Elimination of Racial Discrimination, in relation to the rights of Indigenous people, to traditional land tenure, which has been important in the context of debates on native title. And you can find references for all those things if you Google hard enough. But otherwise, since the negotiation of the ICCPR, the general effort has been to deprioritise property rights at the expense of other progressive rights, particularly social and economic rights. Instead of reinforcing liberal human rights, they've been using an excuse to corrode them by arguing against private ownership and in favour of public acquisition to impose greater economic equality. The decline of property rights as part of the human rights discourse results from a failure to recognise that they are no longer seen as just, whereas a person's absence of property rights is seen as an injustice. And, in part, that is true, but is only part of the human rights landscape. Property rights must reasonably be attainable for all, and I put, of course, asterisks on that. You actually have to work for them. You can't just have them because you, particularly when talking about physical property, because you feel you're entitled. But no one has a specific right to an individual form of property beyond themselves. It has to be secured through effort. And that does matter in a country like Australia. As I went around the country talking to Australians about human rights and freedoms, there are many thematic conclusions I came to. But one of the thematic conclusions I came to, which was strongest, was that people do believe in rights and freedoms in Australia. They just weight them against other competing priorities. We haven't gone off and fought grand crusades or revolutions to secure our rights. We've inherited predominantly from lessons and learnings from England and the United States and their revolutions there. Australians care about rights and freedoms, but they care about them nested with other principles such as fairness and justice. So to prosecute the argument for human rights and its relation and property rights, you have to prosecute them mindful that that is where Australians start, and try and move the discussion much further towards property rights and human rights being fair and just. But there's a real opportunity to reassert the privacy and justice of the human right to property in one area within our country where it is so nakedly denied, which is Aboriginal communities. Through a series of decisions over a period of roughly 200 years, Aboriginal Australians have essentially been denied their property rights. It's intrinsically linked to their incapacity for many communities to develop sustainable foundations. Of course, the establishment of native title in the 1990s, or more should I say correctly, respect for native title in the 1990s with the Mabo decision, started to, of course, redress this denial. But the recognition of native title was really only the beginning of recognising the consequences of property rights denied. Plenty of people who advocate for native title are happy for Aboriginal Australia to have their property rights, but concurrently deny them the freedom to exercise them. Property rights don't just include owning them. They also have to include the freedom to trade them and alter their use or improve their value. Through excessive regulation, even those communities that are granted native title are heavily restricted in their use and has prompted significant legal disputes, notably in the action taken by Noel Pearson against the former Bligh government and its Wild Rivers legislation. That Wild Rivers legislation essentially stopped the freedom for Aboriginal lands to be economically developed, particularly the fisheries. These problems are faced across the country by Aboriginal Australians through the significant economic and environmental restrictions they still face. The consequence is to undermine the self-determination of Aboriginal Australians and communities. And that provides us the perfect opportunity to explain the importance of the primacy of property rights and how it contributes to the outcomes of the human condition and the improvement of the human condition. It is, of course, a natural consequence of the evolution of native title that we are now at a point talking about how we should exercise them. Over a period of roughly 200 years, Aboriginal Australians fought nearly to have title recognised. Then, of course, they've gone through a process of getting it established and getting determinations over particular blocks of land, or often much more significant blocks of land. And then, of course, that they now want the freedom to exercise it so they can build housing, create economic opportunities for themselves, and create better opportunities for their children. Now, I thought this was a relatively straightforward proposition. I know I'm not the first person to work in this space in the Liberty Movement. The Centre for Independent Studies has done work in this space in the past. But as I went around the country talking to Aboriginal communities, it became abundantly clear that while they had been continuing to raise these issues for many years, no one really from the human rights community had much interest. They didn't see the relationship between property rights and its contribution to the interests of Aboriginal Australians. So next month I asked to organise a major symposium or high-level symposium in Broome, bringing together representatives from Aboriginal leadership across the country to discuss, and it's in the title, of property rights. I was worried nobody would turn up. In fact, we're now oversubscribed. We're actually having to turn people away. And the degree in which people are now starting to self-invite to try and make sure they're part of this discussion has gone beyond anything that I could have possibly dreamed of. And what they want to talk about is legal restrictions on their capacity to use their land. And to give you an idea about what exists with native title, if you have a native title determination and your community gets a certain block of land, you're not able to use it as the basis of equity to raise finance, so to build housing, nor can you use it to create your own job or economic opportunities. This, of course, means they can't be participants in a modern market economy or participate in the rest of Australian society to the extent that everybody else can. You know, ordinarily you would call that racist. To be quite frank, there are many people, I have to be non-partisan, so I'll just say in the broad progressive movement, who think that should remain. I would have called that normally racist because in the end it denies some people rights simply on the basis of who they are and where they came from and the colour of their skin. Now some people, and I can understand this, obsess about the importance of native title and moving it towards some form of individual rights arrangement around property. And while I of course have natural sympathy for that position, I don't share that that's the only way you can achieve the outcome. The practical realities, there are significant cultural differences between Aboriginal communities and certainly a lot of white Australia about how we should approach these issues. And it's not as though we don't have arrangements to respect collective ownership and arrangements around economic development within our own existing modern legal framework. Company title for apartments is merely a form of collective ownership over a particular asset that doesn't deny people's access to be able to raise finance or participate. It just carries higher risk premiums because you want to use that as your particular structure. Similarly, of course, corporate structures where people own shares are essentially a broad form of collective ownership. I think we can bridge this divide. I think we can bridge the divide to improve the property rights and the legal framework for Aboriginal Australians to exercise their property rights and significantly improve the economic opportunities that they face. And of course, not only does that enable them the opportunity to participate in the market economy, it also increases the capacity for them to engage in entrepreneurialism and to see leadership from some communities who do it well and to show leadership where others will follow. I think it's the perfect demonstration for all of us about how we can engage in discussion in advancing property rights as part of the human rights discussion. And from that, by cementing those basic principles, educating the Australian population and building up the discourse about why these are so central, we can then move on to substantial other areas of property rights discussion that have just as much impact on every other Australian. Of course, many of the ongoing issues we face in 21st century Australia around issues like housing affordability, in the end come back to a denial of people to exercise their full property rights by placing burdensome regulation on what people can do and how much they can develop, with far too much deference toward collective interest rather than individual interest. And if we address some of those challenges, we would significantly increase the standing and stature of property rights with the Australian community, but also the human consequences and benefits that derive thereafter. It isn't until all Australians are able to own property and to fully exercise their property rights that their full human rights will also be realised. Thank you.
How much time? We have 10 minutes for questions. If we have
right. By the way, do you like my new badge? Again, you know, sort of hypocrisy of people on Twitter. People who don't believe in property rights are now tweeting Coca-Cola asking why I have engaged in some sort of infringement.
Can you please wait for the microphone for the question.
Oh, the question is to Tim Palmer, really.
Top
so,
one.
One of each.
I like the fact that you're now confusing us and we're just kind of melding into the same person.
Okay, to Tim, Professor Palmer, sorry. There are two structural faults in your speech. With the disability support pension, I work in the old Commonwealth Employment Service, and we would try and put people on the DSP because it paid more than the dole. And we also knew that the real unemployment figures in Australia is about 18%, or one job for every 20 unemployed, and about 22% in the United States. So we put them on the dole because it was fairer. And in England, they deliberately put people on the dole, on the DSP rather, to artificially lower the unemployment figures. So, because if you're on the DSP, you're not unemployed.
We're desperately short on time. So
All right, QE. Look, you can, as long as you don't cause inflation, you can print money forever and kick the debt problem down the road forever.
I think we're finding out that the latter claim, we'll talk about that later, is not the case, that there are consequences. The US is a little bit unusual having the world's reserve currency, so they can inflate longer than Australia could, for example. So it's not actually good for the US, in my opinion, over the long term. But on the narrower question, the increasing rise of people claiming permanent disability, I think is a very serious problem, because it is a statement that those people are not expected to return to the labor force. This is very bad also for most of them. The trend in the United States, which I do know better, is very worrisome, and you have more people in their 20s and 30s going on permanent disability. I think this is a sign of a moral decay in society. Although you are quite right, it's convenient to politicians, it lowers the measured unemployment rate. But it is nonetheless a very bad thing for society when people permanently remove themselves from the labor force. It's also bad for them, much higher rates of suicide and other problems.
Right, so was there a question just in here?
Trisha has one.
Yeah.
Hey Tim, I just have a question about coal seam gas. It's not going to be like one of those weird hippie questions, it's a property rights question, obviously. I would imagine that you would have heard some stuff about coal seam gas and property rights.
Yep.
And obviously, because we live in a country with crown mineral rights, there's a conflict between a farmer's right to do what they want with their property. So what is the law currently? How well does it protect farmers' rights to say no to coal seam gas exploration?
Right, thanks for the question. And yes, in fact, part of my consultations again that I deliberately did was I actually went to coal seam gas communities and spoke to ones where the relationship between the coal seam gas industry and farmers and communities was constructive and successful. and ones where there was, you know, put it bluntly, open warfare, where communities were fighting the coal seam gas industry. And I don't know the full details of the legal nuances in each state, because of course, yes, people own their topsoil, the land underneath is owned by the state, and the state governments, and they design laws basically to deal with access. But what became abundantly clear in every discussion I had with these communities was that when people respected property rights and respected farmers, and that they had the, you know, they may only own the topsoil, but they own the access points to land, that the communities were happy to have coal seam gas go on in their communities. In fact, to be quite frank, the ones where it was done successfully, where there was proper consent, that the state didn't simply license the companies to go on people's land without any real respect for farmers, people were actively advocating that they wanted more exploration because they could see the commercial benefits. And because there was a constructive engagement that followed through, because it wasn't done on the basis of state power, it was done on the basis of support and respect, people actually understood what was factually accurate and what was factually inaccurate. They were able to negotiate terms and outcomes, particularly around access to water that was used as part of the extraction process, to their advantage. So much so that some communities who had farmers, it's now the primary source of their income is the royalties they extract from coal seam gas. And in fact, it helps them deal with the challenges of droughts and the sporadic nature of profit and loss that exists with farming. And I don't know, there was recently, I don't know this concretely, but there was recently some ABS data that showed there was an increase in farming employment for the first time in a long time. I haven't gone back to look at that data, but I wouldn't be surprised that part of that is the flow-on consequence of farmers being able to reinvest in their farming community from the profits of coal seam gas. But when you go to somewhere like Singleton, where it's essentially a form of open warfare and there's very little respect for people's property rights, you get a denial or a failure to recognise anybody's interests. And so that basic respect that the state can't license somebody to infringe on somebody else's rights is so central, not just to advancement of the industry and making sure you don't go through huge legal and regulatory problems, but in the end, that you actually foster cooperation and you actually see the market work. And of course, it works exactly as everybody would expect in this room, to advance mutual self-interest.
Okay, so he's normally quite shy, but he wants to ask a question, so I think we should let him. So Peter Phelps, over here.
How do you overcome the problem of tyrannical majorities when you grant property rights to a collective group of Aboriginals rather than incorporating them directly in the individuals themselves and then allowing those people who want to collectively organise?
An excellent question, Dr. Phelps. In the end, it comes back to the legal structures that are set up around what happens when you allocate collective property rights. And I'm not saying it's a perfect solution, but if there is cultural custom or a system where people want to establish and exercise their property rights on a collective basis, you can't then just completely override and say, no, you must have individual arrangements, at least because you've got to deal with the issues of allocation and everything else. But that's why I draw the reference to company title with apartment complexes. They, in the end, suffer from the same challenges. Where majorities make decisions even in my strata title apartment building for the collective interest, and then I'm bound by them within certain parameters. The question is, how do you then set up the body corporates? How do you set up the constitutions to say the tyranny of the majority cannot always rule? And that is an issue of governance. It is not an issue against having collective ownership. But it's also a recognition that not one size fits all. I'm not a believer in telling Aboriginal communities or anybody else what to do with their property. What I am in favour of is setting up the legal and regulatory framework so they can decide what they want to do with their property. And that doesn't mean that you have one determination, native title over here, and you get this block of land, and everything has to be bound by that standard. There are cultural areas which have long-term and significant emotional attachment and cultural attachment which are used for specific. So if communities want to, why shouldn't they be able to carve that out and say nothing happens on that land is collectively owned? But this bit here by the beach, why don't we subdivide that up into individual titles or establish individual leases over that period of time for X period of time, so that we can actually turn it into a tourist resort, into homes, into something like that. Creating a legal framework for people to be able to exercise their property rights addresses almost all of these issues. And in the end, communities have to make that decision for themselves.
Right, short on time. We'll have one more question. If you want to ask some more questions, Tim and Tom will both be around the whole day, so please track them down and tell them why they're wrong. But one last question, Jim Allen.
Thank you very much. It's my first time ever at one of these. So I don't know how you guys reconcile your internal beliefs. I have a question for Tim. So it seems to me, if you just absolute yourself from your job, and I was to ask you, how do you feel about an organization taking my taxes and your taxes, tens of millions of dollars, the Human Rights Commission, and I didn't notice you thanking me for your flight here today, or up to Broome, or all around the country, and this is a group of people on $300,000-$400,000. Many of the reports they produce are, how can we put this, somewhat less than good. So here's my question. If you yourself were not on the Human Rights Commission, would you agree with me that the best thing to do would be to close it up and give the money back?
Before I answer that question, first I want to say, Jim, thank you, and I always enjoy that at every moment that we're in the same room at the same time, you raise basically the same issue. Well, you never asked me that directly either. And the other thing is, I have to pay homage to your shoelaces. If any, just throughout the day, go and look at Jim's shoelaces. They're fantastic. That's the answer. But that's not the answer. The answer is I can't absent myself from my job in this thing. But what I would say is that it is the Parliament's decision whether a Human Rights Commission exists or not. The Parliament has decided to do so. They will continue to do so as far as I can see for the foreseeable future. If you want to win the contest of ideas, you need to engage in arguing against it. But one thing I do feel very strongly is that if there is a body that exists, we must be part of that discussion. At least because the relationship between the evolution of liberalism and human rights is almost perfectly intertwined. And as much as my appointment to the Human Rights Commission drew criticism from some quarters from the left of the idea that how could you possibly have somebody who believes in these awful things like liberty and freedom being part of the Human Rights Commission, the other significant part of it is the criticism of our movement itself. Too often, we have separated ourselves or not been participants in discussions around human rights. I keep reminding people, the relationship between human rights and socialism is virtually non-existent. If you actually go back and look at the history of human rights, more often than not, progressive movements fought against them because it prioritised the individual against the state. And now the narrative of human rights has been completely co-opted and bastardised far too often to be used to advance progressive causes. And I'm somebody who has never been ashamed of going into an environment where you have to fight, one, the contest of ideas, even though sometimes we disagree, and that we should always be on the offensive. Because when you're not on the offensive, of course, you're on the defensive. And I'm quite proud to continue to participate in this argument. I thank you, Jim, for your contribution and your taxes, though I've got to say, as a university academic, that I thank you for my salary, I thank you for my flight to Broome, I thank you, if it makes any difference, the schedule that I do when I travel around the country is absolutely punishing, and I'm sure it's going to be explored for the next 7 estimates anyway, so you can see full disclosure. But thank you for that, but I really do strongly believe that if a body like the Human Rights Commission is going to exist, and you clearly don't think it should be, and it's entirely legitimate political opinion, that we have to be part of the contest, because if not, you just have positions of discrimination commissioners being appointed. And that is what has happened. And I've made this criticism in the past, and we need to keep making sure that those discussions continue into the future for the interests of our movement. Thank you.